The title of today's topic is Protection of Human Rights of Male Prisoners. Now let us have some introduction. The Constitution of India, the supreme law of the land, guarantees everyone living in the country protection of human rights. Article 21 of the Constitution provides that no one shall be deprived of his life or personal liberty except according to procedure established by law. The right to life and personal liberty is available to citizens as well as foreigners equally. Those persons whose fundamental rights have been violated or infringed have a right to directly approach the Supreme Court of India and High Courts under Articles 32 and 226 of the Indian Constitution respectively for judicial rectification, redressal of grievances and enforcement of their rights. The right to move to the Supreme Court to enforce fundamental human rights is itself a fundamental right under Article 32 of the Constitution. In the same tone, Article 3 of the Universal Declaration of Human Rights provides that everyone has the right to life, liberty and security of the person. The International Covenant on Civil and Political Rights under Article 6 Clause 1 states that every human being has the inherent right to life. Thus, national and international human rights laws provide for protection of human rights of all persons, including prisoners. Now, let us come to why prisoners' rights. Individuals who breach the fundamental tenets of law are removed from the rest of the society, deprived of their freedom of movement and subject to numerous further constraints, frequently amounting to an alteration in their legally recognized rights and liberties. Rule 5 of the Standard Minimum Rules for the Treatment of Prisoners 1955 states that social protection is the purpose of punishment. If the protection of the society is the prime justification, then the loss of the rights consequent on imprisonment may extend only to ensure segregation of the offender from the community, and all remaining rights should be safeguarded. If a more punitive approach to imprisonment were to be adopted, whereby an individual was sent to prison for punishment rather than as punishment, then inevitably the residue of rights would be reduced. Persons who are imprisoned do not cease to be human beings, no matter how serious the crime of which they have been accused or convicted. Prisoners are also human beings capable of exercising human rights. In the context of our country, the Supreme Court of India very clearly held in the case of Charles Sobhraj versus Superintendent Tihar Jail 1978 that except for the fact that the compulsion to live in a prison entails by its own force the deprivation of certain rights like the right to move freely, a prisoner is otherwise entitled to the basic freedoms guaranteed by the Constitution. In a similar vein, the Supreme Court in the case of Sunil Batra versus Delhi Administration 1980 held that whether inside prison or outside, a person shall not be deprived of his guaranteed freedoms save by methods right, just and fair. Thus, Article 21 guarantees right to life, and the right to life is not limited to protection of life, limb or faculty. It embraces something more and includes the right to live with human dignity and all that goes along with it, namely the basic necessaries of life, the adequate food, clothing and shelter, and facilities for reading, writing and expressing oneself in diverse forms, freely moving about and mixing and mingling with fellow human beings. The fundamental rights do not free a person. If he is sent to prison, though he may suffer some singrace because of incarceration. A prisoner has all the fundamental rights and other legal rights available to a free person, save those which are incapable of enjoyment by reason of incarceration. Even a convict is entitled to precious right guaranteed by Article 21 of the Constitution, that he shall not be deprived of his life or personal liberty except according to procedure established by law. Thus, prisoners are entitled to all human rights unless their liberty has been curtailed constitutionally. Conviction for a crime does not reduce the person into a non-person whose rights are subject to the whims of the prison authorities. The International Covenant on Civil and Political Rights under Article 10, Clause 1 provides that all persons deprived of their liberty shall be treated with humanity and with respect for the inherent dignity of the human person. This implies that prisoners should be treated with human dignity like other free fellow human beings. Any form of torture or cruel, inhuman or degrading treatment or punishment is offensive to human dignity, which no law on earth would permit and therefore unlawful. The rights of prisoners can only be curtailed in accordance with the law. Prison authorities cannot infringe human rights of prisoners on mere apprehensions created by them. Now coming to standard minimum rules for the treatment of prisoners. Standard minimum rules for the treatment of prisoners were adopted by the first United Nations Congress on the Prevention of Crime and the Treatment of Offenders held in Geneva in 1955. The basic objective of the rules is to put forward the minimum conditions for the treatment of prisoners. Some of the rules are: prison authorities shall maintain the records regarding time and the date of admission and identity of prisoners and reason for his or her custody. Separation of men from women, civil from criminal, children from adults, and untried from convicted prisoners. The prisoners are entitled to all types of facilities like sleeping accommodation, health and personal hygiene, sanitary installations, sufficient natural and artificial light, and ventilation required to meet the needs arising from time to time during various seasons. Every prisoner should be provided at usual hours with food of wholesome quantity and of nutritional value adequate for health and strength, well prepared and served. All sorts of medical care, from general maintenance of hygiene to specialized treatment required for prisoners of ill health, should be made available by the prison administration. While taking up any disciplinary action against the prisoners, due procedure should be followed and only minimum possible or required restraints disciplinary action should be taken for maintenance of discipline and order within the institution. Every prisoner should be provided with written information about the regulations governing the treatment of prisoners of his or her category, the disciplinary requirement of the institution, the authorized method of seeking information and making complaints, and all such other matters as are necessary to enable him or her to understand what his or her rights and obligations and to adapt himself or herself to the life of the institution. Prisoners should be paid equal wages for equal work. Prisoners are entitled for appropriate educational, recreational, and cultural facilities. Now, let us have a discussion on human rights of male prisoners. Prisons have generally become closed and total institutions. Consideration of control and security dictate a great degree of secrecy in their operation. All aspects of life of prisoners are subjected to detailed regulations by prison staffs. In the process of maintaining discipline and control, prisoners are subjected to institutional disciplinary courts which are met by the authorities without consulting the prisoners. The prisoners do not constitute a credible interest group in the eyes of prison authorities, and as such, there is likelihood of showing less respect to prisoners' rights and dignity. The prisoners here too have been denied basic human rights, and the prison administrators have been making decisions placing greater value on maintaining security and institutional order rather than on the dignity of the prisoners. Earlier, the internal administration of the prisons and the violation of human rights and dignity of prisoners were matters which remain beyond the reach of the courts. Now, we saw increasing intervention of courts in prison affairs, and the Supreme Court of India has taken up the onerous responsibility of recognizing and protecting the residuary rights of the prisoners. The prisoners now feel encouraged to move the courts for the protection of their rights violated by prison administration. The courts have an obligation to play the saviors when the rights of prisoners are violated, because the courts are responsible for decisions concerning imprisonment of a person in prison. Male prisoners form the largest percentage of prisons population in every country. In our country also, male prisoners constitute about 96% of the total inmate population. Although women prisoners have some distinct rights different from those of male prisoners, the rights of prisoners are available to all, irrespective of their sex. However, in this lesson, the emphasis is given to rights of male prisoners, and the term prisoner used herein denote male prisoners. It is the higher judiciary of the country which have played an important role in recognizing and protecting the rights of male prisoners through various judgments. Some of the important rights of prisoners are: number 1, all prisoners have the basic human rights such as hygienic food, sufficient accommodation, proper medical facilities, facilities of reading, writing, etc. Secondly, a prisoner shall not be kept in solitary confinement except for his safety and the security of the prison. Third, cruel, inhuman or degrading punishment should not be meted out to any prisoner. Fourthly, use of handcuffs, bar fetters, iron chains is prohibited. Fifthly, prisoners, particularly poor and marginalized ones, have the right to free legal aid and assistance at the cost of the government. Sixthly, all prisoners have the right to speedy trial. Seventhly, all prisoners have right to communicate with their family members, friends, and legal advisors at regular intervals, both by correspondence and by receiving visits. Eighthly, prisoners are entitled for appropriate educational, recreational, and cultural facilities which are required for their mental and physical health. Ninthly, a prisoner shall be paid reasonable wages for the work done. And tenthly, a prisoner can write a book and get it published. Now, let us come to conclusion. The purpose and justification for a sentence of imprisonment is to protect society against crime. The objective of imprisonment is thus not only punitive but reformative and to make an offender a non-offender. This end can only be achieved if the period of imprisonment is used to ensure, so far as possible, that upon his return to society, the offender is not only willing but able to lead a law-abiding and self-reliant life. The prison personnel should be given regular training on the subject of human rights of the prisoners. They should be made aware that a prisoner is not denuded of his basic human rights merely because of incarceration. If an allegation of violation of human rights is proved against any prison staff, he should be subjected to criminal, disciplinary, or other appropriate proceedings. At the same time, the victims of such violations should have the right to claim compensation in accordance with law. To achieve the effective protection of the rights of prisoners, only judicial intervention is not enough, but legal training of the prison administrators are highly essential. It is high time to rethink the ways of organizing the institution of prison, which will sensitize people in general and the prison authorities in particular. Thank you.